So our next panel will be moving to a different question. We just debated the threshold question. Do we or don't we try to do ethics reform in a state constitution or a convention? And now we've presented to you three of the most experienced and expert figures in the state with respect to proposals, actual concrete public policy proposals that might actually be memorialized in a constitution or a convention. Three individuals representing good government groups renowned in the state for years and years and years in terms of their fight for social reform and ethics reform. We have both the Brennan Center of Social Justice, the League of Women Voters, and the New York Public Interest Research Group, represented by Larry Norden, Barbara Bartoletti, and Blair Horner. Larry has to make a train, so I'm going to just introduce him quickly, and then we'll talk a little bit about the next two speakers. For those of you who don't know, I think most of you do know, Mr. Norden is the Deputy Director of the Brennan Center Democracy Program. He has been writing, speaking, lecturing in New York State and around the country about money in politics, voting, and government dysfunction, subjects very much on the electorate, the public, and this distinguished audience's mind. Larry, could you favor us with some remarks?
Yeah, thanks so much for that introduction, and thanks for having me here today. It's really a privilege to be among such a distinguished group. I'm going to talk a little bit about campaign finance reform. There's already been a lot said about it. In particular, in Richard Berfault's opening remarks, he gave some thoughts on what kinds of reforms might be helpful in the state and what might be appropriate for the Constitution. I'm going to maybe try to flesh out those ideas a little bit and provide some additional context and my own thoughts on that subject. First of all, I should say there seems to be general agreement that campaign finance reform is a topic that fits squarely within the subject of ethics. I would say certainly I agree with that. I think it fits. It's most defensible to fit it within the topic of ethics under the kind of broader frame that John Dunn presented in talking about the government representing the people having a choice in who the representatives are, and money not breaking the chain that should exist between the electorate and their representatives. There's a case to be made that the current system in New York is so broken that even when we think of ethics in a more narrow sense, that illegal corruption, that the campaign finance system plays some role in that. Certainly, LLCs were central in both the Skelos and Silver trials, so you could say that the LLC loophole that exists in New York maybe played a supporting role in that. But I think the stronger argument is to be made in the way the Moreland Commission has and that Richard Brodsky did, and that too often money plays a role in driving policy in the state. It seems to me that there should be three goals for any campaign finance reform. One is to reduce the barriers to entry for candidates so that the candidates can run competitively without the support of big money or a conduit for big money. That second of all, hopefully the system itself can strengthen the connection between candidates and the electorate that they hope to serve by incentivizing fundraising from their constituents and from average citizens as opposed to just a few big donors. And finally, reform should look to increase the diversity of those who are participating, and by that I mean not just the candidates, but those who actually give candidates money. So I think among campaign finance reformers, certainly there's broad agreement about what reforms might do that. And a lot of them can be done legislatively. In fact, if you look at Governor Cuomo's campaign finance proposals over the past couple of years. If you look at what was in Speaker Silver's campaign finance proposals in the Assembly, if you look at what Senator Klein recently proposed in the past couple of years, they share a lot of common elements. The first is lower contribution limits. Right now, for statewide elected office, an individual can give $65,000 to candidates, and that compares to about $2,700 at the federal level for even the president. And that doesn't include, of course, the loopholes that exist through LLCs. You have individuals that are giving millions of dollars in a 2-year cycle in the state. And of course, there are other loopholes as well, the housekeeping loophole. The second is a public financing system. If you're going to really lower those limits, first of all, candidates do need to spend money to run for office. One of the most successful systems we've seen has been in New York City, where you have a match on small donations, so that candidates are encouraged to raise money from small donors. And I think we have seen the 3 goals that I talked about: reducing barriers to entry, strengthening connection between candidates and their constituents, increasing diversity, both of candidates and of who gives. You really can see in New York City a dramatic difference once that system was adopted, and in how candidates run in New York City compared to the way they run for state office in New York. In fact, in 2013, about 61% of the amount of money that was raised by city council candidates was raised from small donors. In New York State, that number is about 5%. There's a lot of outside money right now around the country, in large part because of Citizens United. You have super PACs and other, and there's nothing we can do about that until the Supreme Court changes its mind. But we can increase disclosure of that spending. We can make sure that there's as little coordination as possible between those outside groups and candidates, so that that money maybe doesn't have as much influence. So those are things that we should work on too. And then finally, we need real enforcement of all these laws. There's no point in having all these laws if they're not enforced. And I would say of all the bills that I was talking about before that have been up in Albany, that's maybe the weakest point, is they do all these first 3 things that I talked about on enforcement, and getting a good enforcement mechanism. That's been a problem, and there have been lots of complaints about the State Board of Elections. That was true in the Moreland Commission report. NYPIRG has done extensive studies on how little the State Board has done to enforce the current law, as weak as it may be. The governor in 2014 introduced a new enforcement council. I think maybe the jury is still out, but there's still complaints that hasn't worked as well as maybe it should. So I would say, if we're going to talk about what should be in the Constitution and what shouldn't, along the lines that Richard Brafalt suggested, that may be the strongest. There may be the strongest argument to replace the way the State Board of Elections structure, or create a campaign finance board. One of the Moreland Commission's complaints was, and I think it's a fair one, is that bipartisan structure just creates gridlock and makes enforcement and creating new regulations very difficult. So maybe doing something where you have an odd number, as most effective campaign finance boards do, is one way to go. Personally, I like very much what used to exist in Wisconsin, which was the Government Accountability Board. It was recently it was recently kind of destroyed, but the way it existed was appellate judges would pick a group of people that could be considered for serving on that board, that then had jurisdiction over elections and campaign finance issues and ethics issues. I think it's telling that the legislature itself, so the power was kind of taken away from the politicians. The legislature and the governor recently changed the way that that board is structured. And to me, that's an argument about why you might want it in a state constitution. I do think there's an inherent conflict of interest in having political leaders decide who is going to regulate them and enforce actions against them. On the other areas, I have, and I should say these are initial thoughts. I haven't thought about this as much as I should have about whether or not this stuff should be in the Constitution, but I think there are arguments for, as others have said, why it may not make sense to put the kind of details that I talked about public financing and limits into the Constitution. Most importantly, campaign finance systems need to evolve. Public financing systems need to evolve. And if you look at the states that have passed public financing, I don't think it's a kind of comprehensive campaign finance reform. I don't think it's an accident that many did it through referenda. There's a reason that often legislatures are reluctant to do that kind of thing. So if you look at Arizona and Maine and Massachusetts, they all did this through referenda. But one of the problems is they didn't have buy-in from the legislatures. And it's been very, in Massachusetts, the legislature decided not to fund the system. So they have a referendum that says they have public financing, but there was no money for it. In Maine and Arizona, the law changed, and the legislatures and the participation in the programs fell, and you needed further referenda to kind of change the systems to make sure that they worked with that change in the law. If you compare Connecticut and New York City, where those systems passed legislatively, there have been every couple of years changes to the campaign finance systems. The most obvious example is in New York City, where they started out with a 1-to-1 match in their public financing system. They then went to a 4-to-1 match and then to a 6-to-1 match. They kind of lowered the amount of money that could be matched when they did that because there was buy-in from the city council on the way that system should work, and that the goal was to ensure that small donors and average citizens had more of a voice. And I think you do want that dynamic where the legislature is bought in and is working to make the program work.
Larry, I know we may lose you, but let me ask you this one question about campaign finance reform. We heard a lot about it. Is it fair to say if there was a constitutional convention that for so long as Citizens United continues to be on the books, all you're pretty much able to talk about is disclosure and coordination?
No, I don't think so, no.
What can you do in a Citizens United world that really gets at big money in politics?
Well, look, you're not going to be able to keep money out of the politics, whether Citizens United exists or not, probably whether Citizens United continues to be good law or not. As long as Citizens United is good law, you will have super PAC spending money in elections, and that will be a way that wealthy individuals and others can kind of funnel money beyond the limits. But there are a few things you can do. One is you can kind of limit the coordination as much as possible between those outside groups and the candidate. But more importantly, and you can disclose where that money is coming from, but more importantly, I think this is why public financing becomes so important. You want to create a floor for people so that they don't have to rely on that money to be able to run, and that's what public financing can do. And in New York City, you have candidates that had lots of outside money spent against them, but they were able to get enough money through the public financing system and small donations that they were able to run competitively and win. And even in the case of New York City with Mayor Bloomberg, Richard Rifkin mentioned that, he could spend all the money in the world on his campaign, but even there you had a candidate in the last election who ran against him under a public financing system and nearly beat him. So I think the idea of keeping money out of politics is just unrealistic, but what we can do is kind of level the playing field as much as possible and create a floor to give people more choice, basically.
So our next two speakers, when you talk about ethics reform and you talk about change in New York, you talk about Barbara Bartoletti and Blair Horner. They've been doing it and advocating for it for a long time. Ms. Bartoletti has been the legislative director of the League of Women Voters for 18 years and a member going back to the 1970s. For those of you not familiar with the League, since its founding in 1920, it truly has been the preeminent grassroots, citizens, good government group in every respect. They've been on the right side of most every issue for a long, long time. Blair Horner, who will speak after Barbara, likewise has been the spokesperson for the largest student-directed advocacy group in the state of New York, NYPIRG. Likewise, Blair has been a champion for good government forever. Full disclosure, Blair and I were colleagues at the Attorney General's office, where I admired greatly the work that he did in his time there with Project Sunlight, which was a breakthrough landmark event, at least in terms of public disclosure in New York State. So if you two could, we'd love to hear what you'd have to say about issues that might go into a constitution or a convention.
Thank you so much. As I have sat here and listened today, and I will tell you, I look out here and embedded in this crowd are many, 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 many of my members. So thank you all for coming, and you've probably heard much of what I'm going to say for the last 3 decades, but needs repeating often. And I certainly appreciate what we heard from the other panel, which actually kind of moved me a little bit to where I ended up with this discussion this afternoon. I've made the Capitol and the legislative office kind of my home for over 30 years. And as I often say to my members, I've grown up with a lot of these men and women who come into the legislature. And believe me, when I first started, there were many, many more men than there were women. That has been an improvement. We're not there yet, but we're getting there. So I do know that the vast, vast majority of legislators who come into the Assembly and the Senate, they come to do a job for their constituents. They come with every good intention of working to do the things that legislators do. They pass budgets, they pass laws that affect their constituencies, and they do it with little regard to getting hauled off in handcuffs. I don't think anyone comes into the legislature thinking, oh, good, now I can make lots of money and I can, then get indicted, convicted, and go off to jail. So I gave a lot of thought when we first talked about doing this as to, could you really put ethics in the Constitution? And I kind of came to the conclusion, much like my friend Richard Rifkin did, that some behaviors are behaviors and you can't codify them in a constitution. You might be able to in law, and we have nibbled, I think, around the edges of much ethics, not certainly sweeping, and I agree with whoever said that if you hear one more word of sweeping reform, that it has not been. However, the 2 things I would really like to put forward today when it comes to that type, any standards, and one is already in the Constitution, and the other should be more so in the Constitution, and that is, one, accountability. And how do you get accountability? Well, legislators who are really accountable and perhaps maybe after some length of time see openings that perhaps they wouldn't if there were things called competitive elections, which brings me to the first issue, which is redistricting. Already in the Constitution, it's in Article 3, Sections 4 and 5. It's very minutely delineated within the Constitution. And for those of you who may not remember, 2 years ago, we did change the Constitution as regards redistricting. It was on the ballot in November of 2014. The League supported those reforms. Wasn't everything we wanted, but it very rarely is when you're talking about a legislative process. But it is already in the Constitution, and if there was to be a constitutional convention in 2000, probably would not sit until 2018-19, and it may sit for 2 or 3 years, but redistricting will not change in this state until 2022, because as all of you know, redistricting is done after the 10-year census, and then you have to receive the data and get it started. And essentially, why we did and we're so adamant about reform of the redistricting was because this is truly an incumbency-laden legislature. And I can remember distinctly doing this back in 2000 when the incumbency return rate in the Assembly was 100%. In the last 16 years, it's hovered anywhere between 92 to 95 to 97%, depending on the election, and it does change somewhat in a presidential year. But our friends at Citizen Union actually did a study in 2014 which actually delineates the lack of competition in elections. We just don't have competitive elections in this state in the vast number of Assembly and Senate districts. Two or three facts. In the primaries in the 2014 cycle, 85% reached the ballot with no primary challenge at all. That's in the Assembly. In the 120 of the Assembly incumbents, nearly 90% were on the ballot without having been even challenged in a primary, and 31% of all candidates, incumbents and those running for the first time, become elected with no opposition. Now, some of that is demographics, whether you're in New York City, and as my friend sitting next to me, I think, and tell me if I get this quote wrong, in New York City, there are perhaps more telephone poles than there are Republicans, and upstate, there may be more cows than there are Democrats. So some of it is demographics, but much of it is what Larry Norden talked about, the need for campaign finance reform, but redistricting is certainly a huge part. And I've said, my members have all heard me say this, if you are a participant in New York State, your legislators get to choose you before you ever get to elect them. They pack the districts and they design the districts, and they're all designed to ferment lack of any kind of competitive election. Well, when you don't have a competitive election, then you don't have accountability. Now, I wasn't going to talk about this issue, but since Richard brought it up in his opening remarks, and it is in our name, I am going to go from accountability and the need, or let me just go back a minute. If we are to open a constitutional convention, then I think redistricting, they might take another look at that, and they might decide maybe there could be more independence on the independent redistricting commission. The way it is selected now, they might want to look again at that issue. But putting the accountability aside now, we go to the participation side. Legislators who don't hear an awful lot about ethics because they hear about education, healthcare, et cetera, but the vast majority of legislators don't hear about any of those issues because our participation rate, i.e. our voting rate, is abysmal in this state, absolutely abysmal. I mean, we recently in our office, and I think you would find this probably in the boards of elections throughout the state, they have, and in my DMV, we were just told the other day, 40,000 new registrants in my DMV alone. And that says something. It says that maybe this year people are really interested in what's going on. And how could you not be when Donald Trump gets to entertain you? And then there are huge rallies that Bernie Sanders on the other side has 10 and 15,000 people coming to rallies. So there is, we know, that increase in participation rates. But unless you are a new registrant in this state, if you wanted to jump into the primaries and vote in a presidential primary in this state, you're way too late. You would have to have registered in a party back before the previous general election last November. We don't make it easy to vote in this state. Today, as of midnight tonight, if you're postmarking it, I believe is today the 25th? Mm-hmm. Yes. if you want to register to vote in the presidential primary, you will have to have registered by tonight. We don't make it easy. We should make it easier. We should have same-day voter registration. Takes a constitutional amendment. We should have no excuse absentee voting, even as a stopgap before we had same-day voter registration. We should have our deadlines are vastly not voter-friendly, shall we say. Our ballots, now, I'm not sure that could be put into the Constitution. Our election specialist, Amy Allo, could nod her head one way or the other, but we don't have even a ballot-friendly design of the ballots throughout New York City. And yesterday, a reporter called me, or maybe it was actually today, and said that there's so much confusion in New York City that people don't know whether they're voting for their legislators in this primary or whether they're voting for a president. And I said, well, they actually they have 3 primaries this year, not just one, so no wonder voters are confused. Now, these are voting issues are things that can and definitely should be put into the Constitution. We can make participation and then accountability better in the state of New York, and that's would, I believe, if you didn't have incumbency that then breeds a breeding ground for ethics, you could change things in this state, dealing all the way from ethics with accountability and participation that would then, it's just a vicious circle, keeping your legislators more accountable, participating more, et cetera, et cetera. So I would really encourage, if there is a Constitution, voting and redistricting should be looked at again. Thank you.
Thank you all for coming. It's a Friday. It's always a little daunting to be the last speaker because I'm between you and the questions, right, that you want to give. And also the waterfront has been pretty much covered, so there's not a lot for me to add. But the Constitutional Convention question is a big one. It's important. I think the fact that the connection between it and the issue of ethics is timely and may have a big impact on whether or not there is even a Constitutional Convention. As you've heard the statistics before, at least 30 elected officials in recent years have gotten into ethical problems at the state capitol, both the legislative branch and the executive branch. The public sees, essentially in Albany, a political crime wave. They're unhappy about it. 90% of New Yorkers are fed up. You heard the statistic earlier. We have one of the lowest voter turnouts in the country, and I think people view rigged elections with disdain, throw up their hands, and just want to give up. And that's terrible. And so the issue of ethics, broadly defined, deals with some of the issues that Larry and Barbara mentioned. But I guess I'd like to focus on just more narrowly on one topic that I think lends itself best to a constitutional convention itself. And that's the issue of ethics enforcement. Richard Buffalt mentioned this earlier, so this is already covered the waterfront issue, and I'm just sort of underscoring it. The state ethics watchdog in New York has the biggest membership of any ethics watchdog in the country, 14 members. It's even number, so it's hard to get a majority opinion. It's herding cats to some extent, as far as I could tell. It allows elected officials to sit on its board, which makes it unusual in the country. The first chair of JCOPE was an elected district attorney. And JCOPE regulates the lobbying industry, which is a mother's milk of campaign contributions to many elected officials. It allows, as was referred to earlier, weird voting systems where essentially the legislature, legislative appointees can block investigations under the right circumstances. And like magic, despite 3 national searches for executive directors, every one of them just happened to be close aides to the governor. And I think that all of those issues and as you heard earlier from the previous panel, its predecessor agencies suffered from many of the same afflictions. Though they were created as political deals between the governor and the legislature to announce historic ethics reforms, and they really haven't worked. In fact, if you look at who's led the charge in terms of attacking corruption in Albany, it's been the feds. It hasn't been the state watchdogs. The state watchdogs have still been sort of, by and large, snoozing in their little doghouses and not aggressively going out. And why is that? Because they're sort of created to fail. And so people behave differently when they know that laws don't get enforced vigorously. We all drive faster on the thruway when we know there are no speed traps. And ethics is no different. And I think one of the reasons why people think they can get away with the things that they've tried to get away with, but got caught by the feds, is because they just assumed no one cared and no one was watching. And so if you can't create an enforcement agency through the normal legislative process, which is the same process that would advance a constitutional amendment by itself, what are you left with other than looking at a convention? And so that's why I just sort of narrowly focus on this. Richard Berfault mentioned it earlier. I think the idea of creating a new compact between the public and the public servants that they send to the state government, a new compact that stresses the importance of ethics, that creates a new agency that's designed by the public to enforce the laws, is a much more compelling and reasonable argument for an ethics measure that would line itself up well with the Constitutional Convention. Now, let me just be the skunk at the party on this, of course. The Constitutional Convention rules, God knows who gets elected to the convention, who has the time to raise the campaign contributions and run its state Senate districts in a competitive election than the political class that I'm sort of whining about right now. And so there is the rub. The Constitutional Convention, of course, creates opportunities, but you also run risks of things that you might like in the state constitution now, and it may end up that the possibility for reform is smothered by the very people that you're trying to circumvent. But in terms of looking at it, in terms of looking at how could the question that we have here, how could a constitutional convention advance the issue of ethics, I think it's best suited for dealing with the issue, the sort of knotty issue of enforcement, primarily because those who would create the ethics agencies are also the people that are subject to its enforcement, and so they just don't want someone too aggressive. And as a result, we end up with these sort of, the horse created by committee outcome, which is the camel of ethics reforms, which really have not been the sort of, I think, the entities that any of us would want to see in terms of aggressively enforcing the law without fear or favor. So from our view, I think that lends itself up best. I agree with all the previous speakers that there are constitutional issues dealing with voting, campaign finance, and others that also lend themselves to constitutional change, but there are other mechanisms for most of those. I think, though, when it comes to ethics enforcement, it almost is a unique area where it's best left to the people, assuming that that's, in fact, who populates a constitutional convention. So I'm going to be the first speaker to end early because, as I mentioned earlier, I am the person now that's blocking you from asking questions of all the individuals here. So let me stop. Thank you.
So I have just a few questions, and then we'll open up to the audience. Most of what I heard from this panel related to structural changes, either the structure of the ethics enforcement body or redistricting, campaign finance rules. From the good government perspective, do you share the view, I think, that was expressed by some folks that in terms of substantive standards, rules that would apply, to legislators and executive branch officials. There's enough law, enough rules there. It's the structural problems that really need to be got at.
You want to go first?
Yes, as many of the panelists said, it's very difficult. I've had a really hard time, and I mean, some of these brilliant minds on the other panel, wrapping myself around what in ethics could you actually put in the Constitution, except for some of the things we've already mentioned. You could put pension forfeiture in there. You could actually put some type of term limits. The League doesn't happen to agree with term limits, but you could put that in a constitution of legislators. You could put outside income issues, which are hotly debated in the legislature right now. But does that really get at the type of behavior that lends itself to corruption? Is it because people stay around, no offense to Richard at all, for 32 to 35 years?
28.
28, okay.
No, Barbara, that was
that
us
happens
that
to be
have been
the
here.
That have been here for 35 years, yes,
Some of it's
yes.
lobbyists.
But, I mean, is there a sense after a while that, gee, you know, I know the system really well and nobody's looking and I never have to go through a competitive election because, you know, I run unopposed and I have all this campaign contribution and special interest money. Is that what alters my behavior? I may have come in with the best ideas and then after a while go, I don't know, look at everybody around me. Look at all my colleagues who graduated from Harvard and Yale and are, you know, doing very well. But maybe I can, this is a good job, but maybe I can pad my income a little bit. And is that what then makes people slide into unethical behavior? I think, again, we have to keep people accountable and we have to keep the public engaged. And unfortunately, right now, we're not doing either.
Well, I would just say on the standards point, I mean, you know, democracy is a work in progress. You're constantly at it. You're constantly trying to fix it. You never get it quite right. There's no magic bullets, none of that stuff. So there's different questions in terms of standards where you would put things in statute versus things you'd want to put in a state constitution. And so my answer would be, I guess, that we would still want to see changes in terms of what's allowed and what's not allowed in terms of behavior by our elected officials, either branch or any of the branches of government. The question of where you put that stuff in a state constitution is a little dicier because you don't want to have a stagnant sort of ethical situation. It's been widely discussed already that what we allowed 100 years ago, we would not allow today in terms of behavior. And I can already see just in the 30-some-odd years that I've been in Albany, what was perfectly reasonable in the late 1970s and early 1980s is now just not done, although other things are done. So I think there's, you know, appropriate roles in statute. I think Richard Brodsky's comments about looking at trying to use a language around fiduciary responsibility might be a useful thing to look at in terms of the oath of office. But generally speaking, I see those more in a statutory environment, less in a constitutional one.
Some people have advocated, and this would require constitutional amendment, that the legislature should be a full-time legislature rather than purportedly a part-time legislature. And that would be a way of sort of limiting all outside income. I think the argument would be we would get, you know, people less likely to engage in public corruption and the like. Do either of you have a view about that issue, full-time, part-time?
The League is in the process, actually, since we're a membership consensus organization. Our grassroots has to be very well informed before they're willing to give us a consensus and then allow me to go out into the legislature to actually advocate for a position. So we're looking at that issue right now. I think just from stepping back from our League study, if you look at the polling out there is just off the charts with, what do you mean we'd have to pay them $200,000 a year if they were full-time and didn't have outside income? Never mind, I think there's a lot of, often people will say, well, you know, I really like having a pharmacist in the legislature. I really like maybe having a dairy farmer or a farmer from upstate New York, as well as a businessman from the city. I like the variation. I mean, our members are very into this. That's what we talk about. And those are the things I've heard among our members. Wait, we are supposed to have been a part-time coming out of private life and then going into public life and then going back out into private life and sharing those experiences. Now, that may be very pie in the sky. And it doesn't seem to work that way. I mean, many of the people that I came into the legislature with are really either have just left or are still there. So in many instances, and then you get legislators who will say, well, wait a minute, I'm a full-time legislator anyway. I don't just go home on a Wednesday afternoon when session lets out and don't do another thing for my constituents. I go home and I have office hours on Thursdays and Fridays, and I attend every opening of everything that goes on in my district, and I talk to people, and so I am a full-time legislator. So that's, I think, a very knotty question, and I'm not sure there's been any real good justification for either way, and I'm not sure it would lend itself to less ethics problems. Maybe it would.
Well, we've supported the use of the congressional model in New York. We have not said that lawmakers should not be allowed to have outside income. Our argument is that there should be a limit on outside income to reduce the temptation to do what we've seen in the newspapers has happened all too often, where lawmakers have used their public office for private gain. So in terms of the full-time versus part-time issue, it's more, I guess, congressional model, which allows some outside income, but a relatively small amount. And we think that there's a fundamental problem when lawmakers are, well, any elected official is allowed to serve two masters. We think that when you're an elected official, you should serve one master, and that's the public that elected you. If you're a police officer, if you're a firefighter, if you're a teacher, you got to take time off to be an elected official. And we think that rule should apply to everybody. So if you have, you know, most of the lawmakers now do not have significant outside income or any in both houses. So, I mean, that's sort of the way it's evolving anyway, but we think that a limit would reduce the temptation to game the system.
There were two different views, I think, heard expressed today in terms of
just one last thing. I'd apply that also to the executive branch, Richard. We have problems with even members of the executive branch being able to get big book deals.
So I think we heard two different views. They might both be right, but nevertheless the emphasis is different about the problem generally in terms of the quality of performance of legislators and a tendency, as well as executive branch officials, to engage in public corruption. One view is people come into public service with the best of intentions, high-minded, noble, and the system corrupts them. Another view I think we've heard expressed, described as the crisis of participation, is that the best and the brightest no longer are willing to summon the nerve, put themselves in the arena, and run for elected office. Barbara, I think we heard your view about it. Blair, do you have a take on that?
Well, I mean, anybody who watches modern-day American politics knows that it's a brutal experience to run. And I have people that run for office have my utmost respect and sympathy for dealing with it. So I think the sort of the toxic nature of modern American politics drives many capable people from wanting to run for office. That doesn't mean we don't have enough of them. I think we have many people that run for office are some of the people I deal with in the legislature, newer members as well as older members, are extremely impressive. And I felt that for all of the years that I've been there. Capable, smart, honest, hardworking, above and beyond. So I think the sort of the toxic nature of politics and the take no prisoners, consultant-driven system makes the system harder for individuals to run for office than it might have been in the past. So I don't think it's that there's more crooks coming in or more crooks going out. I mean, it's Preparara, the guy who showed up on the scene here. We wouldn't even be having this conversation if he had decided to focus only on Wall Street and terrorists.
So I guess my final question, the $64,000 question, maybe too soon to ask it, in terms of the reform community. is whether to support or not support a constitutional convention. In 1997, many good government groups said no or remain neutral. As that day comes in November 2017, where do you think the reform community will stand? I know you both represent groups that have to figure this out on their own. And in asking that question, let me sort of ask this additional question as you think about it. Someone once said that ethics reform is not for the short-winded.
We can both attend.
I think you could all vote on that right now.
I would say, with the greatest respect to both of you, you have fought the good fight for a long time, but you've been tilting at windmills in terms of trying to get at these larger...
We're optimists. We prefer to
Understood.
say we're optimists.
But here's my question. Isn't campaign finance reform, redistricting, designing, restructuring sort of the electoral process, dealing with the structural issues involving ethics enforcement, is there any other practical venue in which to achieve it? Practical, given you years of relative lack of success on that issue, other than a constitutional convention?
Well, that in itself encompasses another whole question, and that's the question that our membership will be looking at between now and the end of the year. Who will be the people in the Constitutional Convention that would be answering those questions? Would it be a people's, as we like to call it, a people's convention? Would it simply be the same people who could right now change the law statutorily to deal with a lot of these issues? Something we haven't talked about today, it wasn't the time, and maybe at some point there will be a forum on that, delegate selection, meaning who will be able to run to be delegates, and what would their responsibilities be, and would they be the same people that are currently sitting in the legislature? So there would be so-called double dipping and pension doubling and all of the things that took the Constitutional Convention question down to defeat by 2-1 in 1997. Then the League was opposed to the question simply because our membership did not feel that it would be a true people's convention and that there would be the same folks that sit in the legislature every day. I believe Blair can speak for NYPIRG, but we are continuing to look at what might happen. There are some bills addressing some delegate selection issues statutorily in the session right now. I can't tell you that everybody's running down the hall to put in legislation and to make this a better process than it was in 1997. So we don't know where we will be by then. But we will probably make a decision, I would think, by maybe the end of this year or early next year.
We were neutral in 1997, I would say aggressively neutral. We tried as hard as we could to educate people as much as we could on the question. We thought that that was a proper role for us on this issue because it's not, depending how you view the issues in the Constitution, a lot of people, apparently 2-1, were not willing to take the risk. I don't know where we'll be in a year. In terms of, is it the best hope for change, which was the second part of your question, I guess I would agree with Barbara. We won't know that in advance because you don't know who gets elected to the convention. It could easily be that the people that get elected to the convention are not people that are interested in change, at least that's how we see it. So, this is a country that figured out slavery, women's rights. We landed somebody on the moon, It seems like, figuring out ethics in New York shouldn't be so that hard. We just have to keep at it. As I mentioned before, democracy is a work in progress. We keep slugging away at it, and sometimes good things happen, sometimes they don't. So I don't know. Our organization hasn't taken a position. 20 years ago, we took a position in terms of neutral. Is this the best plan B that anyone can come up with? I think it sort of depends. That's my answers.
Thank you. Everybody, please join me in thanking this panel.